That's a question that listeners should have to ask themselves. Do I want the court to be deciding the biggest issues about our lives, our rights, our future, what remains of our constitutional republic? Should that belong in the court? And especially after so many rulings that appear devastating in so many areas.
Hello, everyone. Welcome to Subtext Conversations. My name is Garrison Hayes, and I am your host. I often make deep dive documentary style videos on this channel. And in order to do that well, I talk to experts, people who are thinking really, really clearly about the topics that I'm digging into. And today I want to share with you this phenomenal conversation I had with Cristian Farias. He is an attorney and legal journalist covering the Supreme Court and First Amendment concerns. And I've been consistently impressed with Cristian's depth of knowledge and his ability to communicate these really complex ideas in easily digestible ways. I'll introduce him again in the conversation, but he's worked at Columbia University and Harvard. He's an all-around great guy, and this conversation was really, really informative. So I hope you enjoy it. I've added the links to Cristian's socials below, so be sure to go check him out. So without further ado, my conversation with Cristian Farias. You may know Cristian's work from Vanity Fair, New York Times, New York Magazine, and many, many other publications. Google him is basically what I'm trying to say, and you'll see plenty of stuff out there. So great to have you here. Thanks so much for taking the time.
Garrison, the pleasure is mine.
So the Supreme Court has kind of been the talk of the town for the last forever, but specifically for the last couple of weeks because of some of the decisions that they have come down with in the month of June this year. Of course, June is always when you get a lot of Supreme Court decisions. That's the season. And I think this season kind of started in a way that many progressives saw as positive, particularly because they handed down somewhat unexpected decisions, victories for voting rights activists and Native American activists. But of course, the month ended in a much more predictable way, dealing major blows to affirmative action and student debt forgiveness and LGBTQ protections. And so I want to start with those victories at the beginning of the month, and I want to draw on your expertise to kind of get a better idea about like maybe what people understand or don't understand, maybe bring us up to speed on some of these issues. There's been so much news, so it's very easy to miss some of these things. So kind of want to dig into that, and then I'll have a few questions, of course, on each one. And kind of the major thing for me is like, man, where do we go from here? Right. Like part of maybe the first question I should ask you is like, is there even a way to like salvage this institution? If at the very least, is there a way for us to build public trust in this institution again? Because it feels as though that's a bit lacking. Maybe we should start there. Like how, what is the Supreme Court and what's going on right now?
Yeah, I guess that's a good question to start with, because I'm curious if your listeners do want to build trust in this institution, or they want to lose faith in it and look elsewhere, because power shouldn't reside with the court and should reside with people. That's a question that listeners should have to ask themselves. Do I want the court to be deciding the biggest issues about our lives, our rights, our future, what remains of our constitutional republic? Should that belong in the court? And especially after so many rulings that appear devastating in so many areas, do we want to keep empowering this court to keep making more and more and more and more of these decisions for the next 10, 20, 30, 40, 50 years? Or do we want to take some of that power back? Do we want to trust judges to do this for us, or do we take it into its own hands? Obviously, I don't have the answer for that because it's a very deep political question. But, people should have that question at the end of this term that just ended. Do I want to live the rest of my life like this, with the Supreme Court deciding all these cases until we die, basically? Or it's time for us to do something better, or take some power from it and impose our will on the courts? Because in the end, the people rule the courts. We put them there to make decisions based on the law as we have, and maybe the answer is we don't want them to make those decisions. We want better laws. We want better ways of doing things. And also, a lot of times, as we saw last year with the big abortion rights ruling, the Dobbs decision, that took away a constitutional right that had been enshrined for 50 years. It was pretty much part of the fabric of American society. And the Supreme Court just snatched it away and left tons of people unprotected. And I'm just talking about women or people who can get pregnant. I'm talking about families, people who basically order their lives around this constitutional right. Dobbs affected not just one group of people, but it affected all of us basically. So, and the court ended that decision in a kind of almost uh, ironic way. It said, we're returning the power back to people and their elected representatives. Our court should be out of the business of abortion, and we should let people decide what to do with their fate. And in the past year, the answer has been that, okay, all right, we should take the court at its word. We should take the power back. We should do it. And we've seen it in a number of states, even a lot of conservative states in places like Kentucky and Utah, and there's a number of them where Kansas, where the question of abortion rights has gone on the ballot as a constitutional amendment to their own state constitutions, and the people have overwhelmingly voted for it. And it's been basically across the board without exception. So maybe the answer to your question, it is, maybe we don't want courts to make these decisions. Maybe we do want people to decide their fate for themselves, because whenever we give these huge questions to the courts, we ended up more disappointed than encouraged by them.
Yeah, I think that's true, and well said. I know I said that we'd start with some of the things that they voted and some people perceive as kind of a positive things, particularly around Native American rights
Yeah.
and voting rights. But I wanted to actually jump a little bit ahead, because something you said triggered something for me, which is that, like, returning the power to those elected officials. I mean, the courts feel like a particularly undemocratic element in our kind of three branches of government system. These are people who are appointed for life. They aren't really held accountable by anyone or in almost any way. And I think the student loan decision really in some ways kind of highlights that for me. I mean, this major questions doctrine element of the student loan forgiveness, student debt forgiveness decision, where they said that President Biden did not have authority to forgive student loans, even though within the HEROES Act, as I understand it, there is a clause that says that they can modify or waive. And so it feels like there are elected officials who we have chosen to make laws and to make decisions on our behalf. And then you have the Supreme Court actively working to diminish that ability. Could you help us understand that decision in particular?
Yeah, so that decision was also one of the ones that came out at the very end of the term last Friday, and so the ink is still relatively fresh on it. And that ruling, as you just said, basically shut off an avenue that President Biden invoked to provide student debt relief to 43 million plus people, up to 20,000, 10,000 or $20,000 in some cases. That would have provided a huge lifeline to so many people. And he invoked authority, the president, that is, invoked authority that Congress passed in the HEROES Act. And the language, obviously, it's there. The Secretary of Education shall have the ability to waive or modify the terms of the law in order to be able to provide this relief. And the Supreme Court said, no, 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 no. Waive or modify doesn't mean that. Waive or modify doesn't mean the secretary or the president get to do whatever they want. Oh, and by the way, we also have this new doctrine that, by the way, is brand new, the major questions doctrine that we created, is judicially created, is not in any congressional statute, is not in the Constitution. We just kind of made it up out of thin air. And according to this doctrine, whenever there's a question or a legal question that has a lot of, quote, economic or political significance or economic or social significance, that means that we judges get to decide if this invocation of power by the executive branch is correct and legal. So and so it was a double whammy. Basically, they said no, the Secretary of Education doesn't have authority. and thus the president doesn't have authority to cancel debt at such a mass scale. It's almost as if the justices said, the law doesn't say the president has the power to do, to forgive billions and billions. They almost want Congress to spell it out word for word. But that's not how law works. You work with the statute that you have. Biden worked with the statute that he had. His Department of Justice defended that definition. Again, because it has been invoked many times. Your listeners may remember that at the beginning of the pandemic, not Secretary Cardona, but Secretary Betsy DeVos actually invoked the HEROES Act herself to impose mass across the board student loan forbearance. The reason many people haven't been paying on their student loans for almost more than 3 years already is because of that HEROES Act authority. And that cost the government billions and billions and billions of dollars. So what does that mean? Does that mean that Secretary DeVos also violated the law, or is it just because a Republican did it and it was fine, and now a Democrat does it and it's wrong? So there's no consistency from any reasonable observer watching this from afar in how the Supreme Court seems to apply its own rules. By the way, Chief Justice Roberts, who wrote the student debt decision last week, he has a short footnote in the ruling saying, we're aware that Secretary DeVos and the prior administration invoked this authority, but that program is not before us, so we're not commenting on it. So, it's all very kind of, it's shocking almost. But anyway, it is what it is. And yeah, so basically the question is, what do you do? And in a sense, Biden responded right away. He issued a new directive under a different set of statutes, the Higher Education Act, I believe. And we'll see what happens with that. Will it be challenged in court? I'm sure. Will the major questions doctrine be invoked again? Sure. And the thing is, okay, well, let's see what happens with that. And if the courts again tell Biden no, then the question is, okay, for everyone who's listening, do you want to live with this for the rest of your life? Do you want to, because remember, there's tons of folks in Congress, there's presidential candidates right now who want to win the White House, who are opposed to debt forgiveness. And the question is, well, do you want to work with those candidates? Do you want to vote for them? People who are actively taking steps to say, no, the law doesn't give you this. And that's a question for democracy. It's a question for everyone who wants to make a decision on how to order their futures in their lives.
Yeah, speaking of ordering one's life, I'm going to actually stick to the plan now, Cristian, and go back to Alabama. Of course, there's a decision that came down that deemed that voting districts in Alabama were drawn specifically to disenfranchise Black voters. This, of course, is a violation of the Voting Rights Act. The kind of interesting thing here is that kind of, I want to ask this question eventually. First, I would love for you to kind of orient us, give us kind of the basic details, which you do so well. I feel like I'm learning details and parts of this in context for these cases that I had not gathered from reading from different sources. So I'm really appreciative of that. And so I'd love for you to build out the context of what was going on in Alabama and what this decision from the Supreme Court means for that particular issue. But I'm also really, really curious how this decision, speaking of context, how does this decision square with the Roberts opinion in Shelby v. Holder, which is connected to the Voting Rights Act as well? And maybe, I'm kind of packing in a number of questions here, but maybe give us some of that context and then maybe tie these two issues together for us.
Yeah, sure. So let's start with Shelby County v. Holder, just to kind of take things in order. That was a decision issued 10 years ago in 2013. Insane. And it's a decade old. And basically what the Roberts Court did in a decision, a 5-4 decision authored by Chief Justice John Roberts, he said that a key section of the Voting Rights Act of 1965, which allowed the federal government to, quote unquote, pre-clear changes to election rules and voting procedures, that section is unconstitutional because it treats states and localities different from one another. And the reasoning basically was, why should we have this tool giving the Justice Department veto power basically over Alabama wanting to disenfranchise or wanting to make it harder for people to vote, when, say California doesn't have that, or some other state doesn't have that. Why should we treat states differently like that? And that differential treatment wasn't constitutional. So this preclearance regime went away. DOJ, the Justice Department, doesn't have this authority anymore. States with a history of disenfranchisement don't have to clear their voting changes to the department anymore. They can just go ahead and do it. One thing that Roberts didn't do is eliminate people's ability, communities' abilities to challenge these laws. So let's say Alabama wants to disenfranchise, or Texas, or North Carolina, or South Carolina. Voters and voting rights organizations can still go to court under the Voting Rights Act to challenge discriminatory practices when it comes to voting. And that's what remains. This is the shell of the Voting Rights Act that remains. And it's under this shell that redistricting, which is a subset of voting rights issues that happens every 10 years. Redistricting decisions by states can still be challenged as potentially discriminatory. And what happens every 10 years after the 2020 census, or any census in 2030, 2040, there's a new redistricting cycle where the entirety of congressional districts and legislative district at the state level get redrawn to reflect the new demographic reality of a state. So if a state grows in numbers, or if people move to a different county or whatever, the district lines shift to account for these moves and these changes. And so what happened in the case of Alabama was that obviously in Alabama we have what is known as the Black Belt of Alabama. There's a high density of Black people who live in a very specific geographical area of Alabama that has a lot of historical significance. And they aren't just people who are gathered by race, but they share socioeconomic factors, educational factors. There's a tons of reasons that these groups of Black folks stick together. And basically 27% of Alabama is Black. Unfortunately, the Alabama legislature gets 7 congressional seats, 7 congressional districts, and out of those 7, they only get 1. Black people, or the people in the Black Belt, only get 1, or only got 1 congressional seat. And obviously, 1 seat out of 7 is only 17%. But I just told you that there's 27% of Black people. So it seems like a lot of Black folks didn't get to pick a representative, a congressional representative of their choice, and therefore voters in Alabama sued to challenge this map as racially discriminatory, because Black voters who otherwise would have an opportunity to elect a candidate of their choice were either cracked or packed, according under I'm drawing from the statute, basically. They were cracked, basically separated into other white dominant districts, or packed together with each other so that their numbers get diluted elsewhere. So as a result of that, they said, no, that's unconstitutional. We should at least get another, not unconstitutional, I'm sorry, illegal under the Voting Rights Act. And therefore, we should get another shot at another seat in Congress. And that's how this lawsuit, Allen v. Milligan, took place. It moved up to the lower courts, and the lower courts said, yes, we agree with you. 3 judges, 2 of them, by the way, appointed by Trump, they agreed, yes, this is discriminatory. Alabama should redraw their districts to include 1 additional Black predominant district, so that at least Black voters in the state have an opportunity to elect 2 candidates. And the Supreme Court, to the shock and surprise of many, myself included, upheld that decision by the lower court and upheld decades of precedent under the Voting Rights Act, saying that it is possible to challenge racially discriminatory maps under the Voting Rights Act. And obviously it's a big surprise, because the author of this decision, Allen v. Milligan, was Chief Justice Roberts, again, whom we will see as we continue through this podcast, he has a starring role in many of the decisions this term, including Allen v. Milligan. So it's significant. I was shocked because, again, he wrote Shelby County v. Holder 10 years ago, and then 10 years later, he comes back and actually votes in favor of Black voting rights, which is something that many, many, many people were not expecting.
Yeah, I certainly did not expect it. And given the context, I unlike you, I can't quote, exactly the language used in the opinion. But if I'm remembering correctly, a part of the justification for, kind of taking the teeth away from the Voting Rights Act and that pre-clearance element of it, a part of that justification was that our country has kind of progressed. We've moved on. Like we don't need these things anymore.
Things have changed in the South, I think it was the language.
Exactly. Which, of course, putting that within the larger context of Obama, winning a second term and kind of that larger kind of context felt relevant to this decision that we have seen. I think there is evidence to suggest that we actually did need that, because places where Black voting rights have been most violated are actually in the very states that were once held under this kind of pre-clearance requirement. And so it felt necessary. And it also feels as though this district would not have been gerrymandered in the way that it was gerrymandered if that pre-clearance element to the Voting Rights Act was still in place.
Yeah,
is that correct?
matter of fact, if Shelby County hadn't happened 10 years ago, Alabama would have had to go to the Justice Department under Joe Biden because he would be president now. And Justice Department would have said, okay, is this legal under the law? And they probably would have rejected it, and that's the thing. That's why it was a vital tool, because you had this disinterested actor in Washington basically making these decisions whenever states with a history of voting discrimination try to pass new maps, new rules, new voting restrictions. And the Justice Department almost had a veto power over it. But now we don't have that anymore.
Which feels pretty, it's frustrating for me. And I know for many others, it's frustrating because if I'm understanding correctly, this map was utilized in a recent election.
Yeah,
is that right?
It was used for the 2022 election. Matter of fact, last year when the map was challenged, the judges in the lower court said, no, you have to redraw it. It has to be done in time for the 2022 midterm elections. But unfortunately, again, the Supreme Court blocked that order by the lower court. So in essence, we had one election cycle in which Alabamans had to vote using an illegal map. But now that map is going away. There's a new one that needs to be drawn. And hopefully this violation will be cured or remedied for the next cycle. So yeah, absolutely. And the Supreme Court played a role in that. And again, it shows that even outcomes that appear to look like victories, there's also some injustice that they leave behind, because there was one cycle in which voters were basically denied a candidate of their choice.
Yeah, that's frustrating. Let's move on. This is one of the ones that I feel like kind of ran a little under the radar for a number of reasons. One is that our country really does not pay nearly enough attention to what's going on in the Native community for, again, a few reasons, but the erasure is very, very real. So bring us up to speed on what happened in this particular case where Native American sovereignty was upheld specifically with regard to adoption.
Yeah, this case is called Halan v. Brackeen. Halan is the Secretary of the Interior. She happens to be Native American, and Brackeen is the name of a white adopted family who brought a lawsuit in federal court many, many years ago, challenging the Indian Child Welfare Act, which is a historic law that Congress passed many decades ago, basically designed to ensure that Native-born children remain with their tribes should the child go up for adoption. The law gives predominance or gives preference to Native families so that the child may remain with a Native tribe. And again, it's a law that has been in place for a long time. The law was passed in response to centuries of discrimination, dispossession, and plunder by the federal government and by the states against Native Americans. And in a sense, many people expected the Brackeen case to be almost yet another big loss for Native Americans, because Native Americans, unfortunately, don't have a great record before the Supreme Court. The Supreme Court isn't entirely protective of them. They have a long history of ruling against their interests. And basically, this many saw it as an existential challenge to this law, because it was challenged on a number of grounds. I won't bore you with the details; they're a little bit complicated. But the main question, or one claim that many thought would mean the death knell to the Indian Child Welfare Act, was something that I kind of alluded to earlier, that in giving preference to native tribes over adoptive parents, that the law was quote unquote racially discriminatory, because it's given preference to Indian country over the states or over families. And many of these families are wealthy and white, and they just want to have native babies. And the question is, does that violate the Constitution's promise of equal protection of the law? And the Supreme Court didn't answer that question, luckily. And I say luckily because, as we will discuss later on, again, whenever the Supreme Court touches the Equal Protection Clause, the Supreme Court has historically, but particularly this court, which is dominated by 6 conservative justices, they have a colorblind, quote unquote, idea of the Constitution, that the Constitution doesn't see color, that the Constitution shouldn't discriminate in any way to anyone, that reverse discrimination is discrimination, or that affirmative action is in fact racism. That's kind of to give you a gist of how this court views questions of equal protection. So there was a real risk that the court would strike down ICWA, as the law is known, because it discriminates against white adoptive parents, and because that's a racial preference, and the Supreme Court tends to find those things kind of icky, they feared that it will go away. But the court didn't answer that. The court left it for another day. It didn't reject it altogether. It just said, all these families, all these states that are suing us to strike down ICWA won't get to do it because they don't have standing to sue. And because they don't have standing, these claims go away. But yeah, many Native Americans breathed a sigh of relief with this ruling, and they averted this challenge, which I should note, this challenge isn't just some, the product of some really loving, thoughtful families who want to adopt Native kids. Although I'm sure many of these families do, in fact, fit that criteria. But there's a lot of kind of special interest behind this lawsuit. Lots of conservative institutions, organizations, a lot of industries, and just conservative interests basically funded this legal campaign against the Indian Child Welfare Act. So, and by the way, if I can interest your listeners, there's a podcast called This Land by Crooked Media, which basically is an in-depth look at this entire case, what it means for Native Americans. It was produced and it is hosted by a Native American woman, and so she knows very well what went into it. And if you listen to it, you will learn really what this case is about. And the fact that Native Americans have dodged this bullet for now, it's a good sign. But again, with this court, communities are never in the clear. There's always a chance that someone might have standing to sue in the future, and then at that time, all bets are off.
I don't want to, overwhelm the listener with me fawning over just how knowledgeable and clear you've been. It's been really, really helpful. I'm learning a ton here, so I just want to say thank you.
Oh, you're welcome.
Yeah, this is awesome.
But fawn away, it's fine with me. No, I'm kidding.
Yeah. Keep it coming. Okay, so you mentioned standing, which we will certainly come back to in our very last case, which is around LGBTQ discrimination. But you've also mentioned these special interest groups that have what I would describe. I'll just speak for myself. What I would describe as a uniquely nefarious intent in bringing these suits and bringing cases and strategizing in a way to overturn certain laws and procedures. One of which would be affirmative action. And of course, I've made a video here on this very channel about Edward that touched on Edward Bloom and his organizations and the efforts to undermine affirmative action, even the reskinning of this issue in a way, right? We think about Abby Fisher with Fisher versus Texas 1 and 2, right? And then the kind of reskinning of this issue to place Asian Americans in kind of the seat of those being violated. But
If I may interrupt you for a second too.
Please do. If I'm getting anything wrong,
no,
please
no,
interrupt
no.
me. Go ahead.
It sounds good. No, actually, this may blow your mind, but Edward Bloom actually also brought the Shelby County case at the Supreme Court. So he's definitely on a roll.
He is on a roll, a uniquely anti-Black roll, if you ask me. Please tell us more. Talk to us about the affirmative action case, and I have a lot of questions here, but I'm certain that you'll help us understand it better.
Yeah, actually, the affirmative action, these new set of affirmative action cases were filed back in 2014. 2014 was the year that I was finishing up law school, and it was the first year that I kind of became really serious about becoming a legal journalist. So I'm very familiar with the start of these cases. And again, at the time, they were unprecedented. Not so much because Edward Bloom was bringing them. Many people knew who Edward Bloom was, not just from Shelby County or from the prior affirmative action case known as Fisher versus the University of Texas, which some people may remember. Abigail Fisher, the white woman plaintiff who was at the center of that case. That one was a wash. That one was sort of rejected by the Supreme Court, but again, it left the door open to a future challenge. So Edward Bloom kind of restarted his strategy. He said, okay, I guess this white woman gambit didn't work. I need to try a different strategy, I need to try different plaintiffs. And he decided to recruit Asian American students who have been denied admissions at flagship elite universities. And the two that stuck out the longest were Harvard and UNC. And the reason why Harvard and UNC is, again, strategic. Harvard is the most elite of elite institutions. It's private, but it receives a ton of federal funding. And UNC is just a school that was literally, as I said in one of my pieces, it was literally built by formerly enslaved people, but also it has a history just of having a very diverse student body, and it's a state school. So to sue a private school and to sue a state school is slightly different strategies. The state school, you sue under the 14th Amendment, which prohibits the denial of equal protection of the laws. And then Harvard, you sue under Title VI of the Civil Rights Act, and Title VI forbids discrimination on the basis of race and other protected categories for any organization that provides an educational or who receives funds from the federal government under Title VI. Anyway, so he brought these two separate cases under these two separate theories using a very similar strategy, recruiting Asian American students who have been denied admissions. And basically, what made these cases compelling, at least from a public narrative perspective, it wasn't so much the plaintiffs, because the plaintiffs, to this day, we don't know who they are. They are largely shrouded in mystery. They were shielded from having to say who they were, their names, etc. We just know some very vague details about their lives. And for many in the Asian American community, it seems as though these plaintiffs were used in order to drive a wedge in the Asian American community, because the Asian community, much like the Black community, much like Latinos, they're not a monolith. You know, Black people are not a monolith, neither are Latinos, neither are Asian Americans. Asian Americans, you have so many people from different parts of Asia that make up this huge group of folks. So to use one specific subset of plaintiffs to say that all Asian Americans are being discriminated against, it's almost, it's kind of crazy when you think about it.
Hmm.
So many Asian Americans did find this lawsuit offensive in that regard, because many Asian Americans do support affirmative action, do support the fact that colleges don't have quotas per se, but they do take into account race. They do take into account ethnicity and the challenges as a racial minority that you have in order to overcome challenges. Going to school, just the mere fact of taking the SAT or the LSAT or the ACT or whatever test they use these days. I'm removed from that world now. But there's a lot of structural challenges to even taking a test like that. That if obviously you have the means to do it, it's easier. But for many people who are of more modest means, it's truly a challenge. So schools are really trying to look at various factors, of which race is just one, to accept people into their schools. So, these challenges went ahead, and I think what made them so compelling over the years, litigation takes tons and tons of resources and money and time, is that once they got into courthouse, once Edward Bloom and his Students for Fair Admissions, that's the name of the
Hmm.
organization that houses these lawsuits, what it's called. Once they got into court and they were able to go to trial, they were able to basically open up the books of Harvard University and UNC and read all their emails, all their documents, and they hung on to every little single piece of detail just to try to prove their case that they were discriminating on the
Hmm.
basis of race. Obviously, the lower courts, all of them rejected these challenges. They said, no, they're not violating precedent. No, they're not discriminating uh, on
Hmm.
purpose, or even in effect. But again, the Supreme Court had other ideas, and the Supreme Court used these two cases as a vehicle to almost basically scrap affirmative action precedents from the books, which have been with us since the 70s. 50 years of precedent are down the drain. Chief Justice Roberts, again, the one who
Again.
authored this decision, he pretended to apply these precedents to say that these programs were unlawful under the Equal Protection Clause and Title VI of the Civil Rights Act, and because of the way they were designed, because of how they were managed, and how Asian Americans did suffer under this program, according to him and the majority, that these programs had to be struck down, and basically race, or the consideration of race, to reach a diverse student body. And I'm using language from Supreme Court opinions from the past. Diversity has always been a compelling government interest that schools may take into consideration when designing their admissions policies. Race no longer is reaches that level, and therefore now schools are almost functionally barred from considering the race of an applicant at the moment that they seek admission, and they must rely on anything else but that. And yeah, that's the gist of it.
No, that's helpful. It feels profoundly arbitrary to simply bar that one component when, we know that students in, say, Appalachia are underrepresented in STEM. And you can take that into consideration. You can take gender into consideration, which, if I'm understanding correctly, we have you here as the expert for a reason. But if I'm understanding correctly, isn't gender a part of the enumerated in the equal protection clause? Like, isn't that a specific protection in the Constitution? And so what makes that okay but race not okay?
Yeah, it's interesting. Yeah, the Equal Protection Clause says no person. So no person means it could be on the basis of race, gender, or a protected category or characteristic. And yeah, again, schools now are going to have a harder time justifying their admissions decisions. I don't know if you saw the news, but
Yeah.
there's already organizations that are saying we're going to sue. We're going to be watching that schools are obeying the language of this ruling, and if they don't, we're going to sue them again because, as Chief Justice Roberts put it, eliminating discrimination means eliminating all of it. I don't know what that means. Justice Sotomayor, who was a dissenting vote in this case, said something to the effect of eliminating or upholding racial equality means taking care of inequality. So again, it's a war of words. It's a war of ideologies, uh, different visions of the Constitution, and again, it's a really interesting moment to be looking at these decisions because it's as we all know, and I'm sure listeners of your show know, we are nowhere near that more perfect union that the
Right.
Constitution says we should be, and the country is still struggling along to be more equal and more accessible to all. So to shut off this one avenue, it seems like states and different colleges and universities are going to have to innovate. And the reality also is that, as Justice Sotomayor put it in her opinion, diversity is here to stay. The court may not think is a compelling interest anymore, but you need diversity in the jury room. You need diversity in the boardroom. You need diversity in corporate America, in the military. The military having a diverse armed forces is a national security imperative. You cannot have the armed forces looking one way only. Look at the judiciary. Having a diverse bench also it's necessary because that's the only way you foster trust in the
Mm.
courts when the judges themselves look like the communities that they represent or that they serve. So to have this view that diversity is a non-issue or shouldn't be an issue, and that whenever the government takes it into account is wrong and unconstitutional, it's simply not reflective of the reality that we're living today.
Yeah, I did. I made a piece of content on my Instagram and TikTok where I look at the early admit or the early action process for Harvard. About 10,000 students apply for early action. About 750 of them are accepted. And you can whittle these numbers down. About a third of them would likely be considered, legacy admissions candidates, admitted on legacy admissions, ALDCs as they're called. About 200 of them are going to be from the Asian community. A mere 50 students are going to be from the Latino community. And about 65 of those admitted on early action will be from the Black community, about 12%. And so when you think about 65 Black students admitted on early action, I think it really, or 50 Latino students admitted on early action, these two groups being those who are most impacted by this decision, it feels almost absurd to frame this as some type of theft or violation against the Asian American community. I lament, here's my personal perspective. I lament that element is now a part of the conversation, that we're going to have to kind of unwind that in order to have a more productive conversation. It's just really a distraction in so many ways, especially when the conversation, and I'm thankful that the conversation around legacy admissions is really growing. But it's profoundly unsettling that that's where we're having to have the conversation, especially at the beginning, which is this kind of idea of like, oh, well, Asian Americans have been violated, when the group violating them, maybe reasonable minds disagree on whether or not a specific group is being violated here. But if there was a group to be accused of the violation, it's likely those who are admitted on legacy, who are the children of donors or the children of faculty. And it's not even that I don't want those groups to be admitted. It's just that if there's any kind of disparate or disproportionate impact, it's probably coming from that subset of the admitted population and not the 65 or 50 students who've been admitted to Harvard on early action. Those aren't the people who are doing any of this violation. Those people, I think there are far more than 65 qualified Black Ivy League applicants, Harvard applicants. I think there are far more than 50 qualified Harvard applicants from the Latino community. And so it just feels so kind of ridiculous, to be honest. And I'm a little frustrated and trying to kind of find my words here. But it kind of comes back to your question, which is like, is this the kind of world that we want to live in? And, in that, my answer to that is absolutely not.
Yeah, and in a way, also the opinion leaves it open. I think John Roberts says at the end of his opinion that none of this prevents students or applicants themselves to bring up their own race
Sure.
in their own letters of admission, saying how they overcame racial barriers or discrimination in their own lives. And I'm sure schools are going to get flooded with letters of this kind to show that discrimination is in fact a reality of daily life, that they have to, many families have other family members who are facing incarceration, who perhaps have immigrant parents who work 24/7 and therefore cannot be there with them to help them along in their school needs. And they had to overcome all these real life scenarios that are very much part of the racial identity that you cannot escape. It's simply almost impossible to escape that reality. And schools obviously are going to have to think twice and be wise about how they use that information so that they don't get sued again and accused that they're using race as a proxy for all these other barriers that students have to face at the moment of seeking admission.
Yeah, and I think I do recall that being a part of it. And I think that's a helpful little avenue. But I also, to be totally honest with you, I resent the idea that the value of my race is almost parasitic to suffering and oppression,
Right.
or that it has to be necessarily tied to overcoming oppression in
Yeah.
order for it to be counted. I think
Right.
we really have to kind of answer this question. Is diversity of perspective, opinion, experience, is diversity valuable? And I think that, like a Chilean person who's applying to be a part of an educational community is valuable because they have a specific set of
Yeah.
experiences, a heritage, a perspective that may be and likely is underrepresented in that community. Of course, shout out to the Chilean people, on
Including your guest, Christian,
including my guest,
a
including my
Chilean
guest,
immigrant many years ago. But,
precisely.
yeah, by the way,
With
I didn't go to an elite school. I went to a community college and then to a state school. But again, many of us had to face different situations in order to go to school,
precisely.
different realities, and it's indeed quite something that it's gotten to this point with the Supreme Court saying that race cannot be considered at the moment of admissions, considering the history of discrimination in this nation. For me, as a legal journalist, what worries me more is that this vision of color blindness, that the Constitution is colorblind, is seeping into the discourse as if it's a fact of life, when the reality is that
Mm.
the 14th Amendment, when it was enacted in 1868, more than 150 years ago, uh, the amendment makes no mention of race. It says no person uh, uh, shall be denied the guarantee of equality. But the 14th Amendment was very much a race conscious amendment because it was designed to ameliorate and to counteract centuries of subjugation and discrimination. And the Congress that passed the 14th Amendment, uh, did a whole bunch of things, passed a whole bunch of laws, created a number of agencies precisely to lift up the formerly enslaved Black population. So, to say that all of those efforts were colorblind almost defies reality. I'm concerned that the Supreme Court is advancing this narrative because this narrative, many historians will tell you, is not part of the record of this country.
And if memory serves, one of the things that I wish we had more of, I wish we had a camera in the courts, because if memory serves, Justice Ketanji Brown Jackson actually made that exact argument that the Constitution is actually conscious. I believe
Yeah.
during oral arguments for this very case back in, I want to say, October, and it kind of feels like, man, if we could just see some of that, right? Like I think video is really powerful, and if some of that stuff was visible, if those clips could go viral, like I can absolutely take the audio file and like try to piece it together in an interesting way, but the visuals really matter. And sometimes, that's a different conversation for a different day. But she did make that argument that the Constitution is not race blind. It's quite conscious of race.
Yep, absolutely. And everyone should read both Ketanji Brown Jackson's dissent and Justice Sonia Sotomayor's dissent, because both of them very powerfully lay out this history.
Yeah.
and what it means. And the question is, will the people and the country just accept the version the majority offers or what the dissenters offer? And that's up to all of us to decide.
Yeah, I like that theme. There's some things for us to decide. Okay, you've been very generous with your time. We're to the last case here, the last decision I should say, which is 303 Creative. This one is all about LGBTQ discrimination, but many have been talking about there are downstream implications that are really important to consider here. So maybe catch us up to speed on this one. What happened? Who are the different sides here? And maybe how will this continue to play out in the lives of the American people?
Yep. So basically, 303 Creative is a follow-on case from a case that people may have heard of in 2018 called Masterpiece Cake Shop versus Phillips. And Masterpiece Cake Shop, the case, it so happens both cases come out of Colorado. Colorado happens to be a very progressive state when it comes to anti-discrimination laws and public accommodations laws. Public accommodation laws are basically a product of the civil rights movement. If you can sit at a lunch counter or a restaurant or go to any place and not be excluded on the basis of who you are, your race, the fact that you're a woman or a sexual minority, that's the result of public accommodations law. If you open up your business to serve the public, you take all comers. You don't make exception as to whom you serve. That's the part of doing business in a state. You just serve everyone. You don't get to discriminate. And again, it's something that's been with us for decades and decades and decades now. But now many states are also including discrimination on the basis of sexual orientation as a reason for affording extra protections under current civil rights laws. And unfortunately, in 2018, the Supreme Court couldn't decide the question of whether creating something, and in that case, it was a bakery item, a wedding cake for a same-sex couple, and that counted as speech, and therefore the state couldn't force a baker to create something that was considered speech because the creator, in this case the baker, opposed same-sex marriage on the basis of his own Christian beliefs. Now, it's an interesting kind of hypothetical because on the one hand, you have a baker who is raising his own conscience and his own beliefs as a reason for denying service. On the other, legally speaking, the case is not being framed as a religious question. It is being framed as a speech question. Can the state compel you to create something for a protected group on the basis that you object to the message that you're conveying? So it's not framed as a religious liberty question. It's framed as a speech question. The court couldn't answer that question at the time in 2018. So this case, 5 years later, came back. This time in the form of a website designer who who had a business or who has a business that basically creates websites for couples or for other people wishing to promote their lives, their businesses, what have you. And it so happens that because of Colorado's strong anti-discrimination laws who protect same-sex couples from discrimination, Laurie Smith, the owner of this business, 303 Creative, brought a lawsuit challenging this law, saying that it violated her right to speak a message that that went against her beliefs. And in this case, creating a website celebrating an upcoming wedding went against her beliefs. And the state, she argued, cannot compel her to create this message because that was a violation of the First Amendment right to free speech. The state cannot compel you to say something that goes against things that you believe in. And the Supreme Court now, that looks far different than it did in 2018, has a number of new justices, agreed with this claim, ruled in favor of Laurie Smith, and agreed that the state of Colorado violates the First Amendment because it's compelling this website creator to speak a message that she does not agree with. And I guess you could kind of see a little bit the allure of that argument, in the sense that imagine if a state passed a law saying, all right, Garrison, you must have Nazis on your show and you have to let them speak whatever they want. You know what I
Right.
mean? But you're gonna
Right.
say you can't make me speak a message that I don't agree with. You know what I
Right.
mean?
Right.
So there's some kind of I could see kind of the why that argument makes sense from a purely speech perspective. But one thing that this decision doesn't do, this decision was written by Neil Gorsuch, it doesn't delineate what counts as speech. What kinds of businesses are involved in speech. Is a baker engaged in speech? Is a wedding creator or a wedding
Right.
website creator engaged in speech? What is considered speech? And because there's no bright line rule, this case only opens the door for, as you said, potential downstream effects, but also more litigation just to try to get at what counts as speech, what counts as compelling someone to speak a message that they disagree with. Uh, Obviously, we all agree that if you go to uh, a store to buy widgets, or I don't know, if you go to a hardware store to buy nails, that's not speech. They still have to serve everyone, no matter who you are. But there's other kinds of businesses. If you're a speech writer, or I don't know, if you create a podcast, or if you're a ghost writer for others, do you have to take any customer that comes your way, even people who hold repugnant views that you disagree with? And because the court didn't delineate that, it remains to be seen what's going to happen. But it definitely has the potential to open up Pandora's box, and we're going to see what happens with this.
Yeah, I think Justice Jackson, brought up the example of there being a photographer at a mall for during Christmas time, right? What if they say it is my artistic expression to only take pictures of white children? Is essentially the paraphrasing the example that she gave. Would that be a part of her this photographer's free speech First Amendment rights, right? Would they have the right to discriminate against this long line of, let's say, Black or Latino kids who want to take pictures with Santa, and they say, oh, I won't do that. We don't serve those kinds of people here. And I think it's a legitimate question because, again, it helps kind of to push forward this idea that this is opening up, to use your language, Pandora's box around what is acceptable discrimination. I
Like
had an
what if,
interesting conversation.
what if
Please go ahead.
what if a Black couple, goes to another website designer, and the website designer, and there are people who believe this, so they say, my religion teaches that interracial marriage is wrong, so I'm not going to make a website for you because you're an interracial couple. And I don't think that the races should mix. And my God told me so, and I believe that in my heart. What do you do? And unfortunately, the Supreme Court doesn't answer that question. Justice Sotomayor, who wrote the dissent in this case, she posed that hypothetical, and she said there was no answer. So who knows what's going to happen? So again, a lot of unresolved questions.
Yeah. Now, speaking of Justice Sotomayor, she also wrote in her dissent about how this kind of opens the door for folks to have like no gays allowed signs or a no blacks allowed sign. Because if I'm understanding correctly, a part of this was that Lori Smith wanted to say explicitly on her website that she did not serve gay couples. Am I getting that detail right? I know that that's in the dissent, but was that a part of Lori Smith's 303 creative complaint and all of this? Was that a part of it?
Well, she definitely wanted to make it clear in her website. I don't know if she does currently, but she wanted to make it clear what her beliefs were. I don't know if she wanted to say it in all those words, no gays
Sure,
allowed, but
sure.
more like, I'm a Christian website designer, and I only create websites for heterosexual couples, or something to that effect. But again, the question, because the Supreme Court didn't get into all the other hypotheticals, it leaves the question open. Can you just advertise your views to the world, no matter how out there they are? And does that constitute discrimination? Forget about sexual orientation, but all these other beliefs that people hold. People hold all kinds of beliefs. Are you now allowed to advertise them? And because of the lack of clarity, we simply don't know, and it remains to be seen what happens to these kinds of scenarios.
Yeah. Okay. listen, again, you've been very generous. I have a kind of a final question here,
Sure.
which is like, what would be the impact of packing the courts? And how, and is that a viable response? Should people be pressuring the president, calling their senator, their district representative, and saying, we want to pack the courts, we disagree with these decisions, we need a more balanced judiciary at the highest level? Is that viable? And what would it make a difference?
Uh, as a journalist, I'm not going to tell your listeners what to do in regards to this question. It's obviously a very
Great.
controversial one, but I can tell you this: Congress has the power to do pretty much anything it wants with the Supreme Court. Throughout its history, it has shrunk the court, has expanded the court, it has kept it the same. It is for the past 150 plus years that it's been at 9, but before it was at some point it was 6, 5, 10, I believe, at one point. And the point of all these proposals, it's not so much can it be done or not. It is
Mm.
obviously possible to do. Can Congress do it now? Does it have the power? Does it want to do it? Do people have the political will? I think that's one question, but the more important question is kind of what we started the show with, and that is, do we want the court deciding all the most important issues of our lives? And when you think about it in those terms, instead of maybe saying, should we pack the court or should we supersize it, whatever you want to call it, is that, do we want to a regime in which they are deciding everything? And there's other things that people could do. They could choose to impose term limits on justices rather than serving for life. They can serve for, I don't know, 18 years, 14 years, as, for example, happens in New York State. They could also do what is called jurisdiction stripping, which is saying, all right, Congress decides to pass a new Voting Rights Act. It takes Justice Roberts at his word and passes a new law that allows DOJ to pre-clear all voting changes. But then there's a provision that says no court shall have any jurisdiction over this law, meaning you strip the courts of the power to even assess the legality of that statute. So again, those are mechanisms in which you're telling the courts, you stay out of this. We decided this. We want this. We don't want to do away with it. You courts do not get to decide the legality of this. And then, the other thing to do is to pass broadly popular laws that people support, and laws that have a lot of just the democratic backing, that are passed by broad majorities, both in Congress, but also, passed by popular presidents, so that the courts will tremble at the prospect of doing anything with them, and especially, we've seen what's happened with over the years with things like Obamacare, Social Security, and other popular statutes, Medicaid, Medicare, that are very much a part of American society. The courts are not touching those. And it's because, again, they have passed the test of time. Congress has funded them and reaffirmed them time and time again. And the other answer is just to keep passing broadly popular laws that help people. And the more Congress does that, I think that also decreases the chance that judges will try to meddle and do something that goes against the will of the people.
Cristian Farias, you've been so helpful. Thank you so much. A lawyer, legal journalist. You can find him on Twitter for sure. Are you on any other platforms? Are you on Threads? Have you jumped onto Threads yet?
I'm not on Threads. I'm on Blue Sky under my name, and which is a new platform by invitation only. At one point, they'll open it up. I'm on Instagram too, although it's not really a work Instagram, but you can follow me if you want. I don't care.
Yeah.
And yeah. All my takes for now are on Twitter and Blue Sky. So be sure to hit me up there. And if you have questions, of course, write to Garrison, and he can pass on your questions to me.
Of course. You can find all of Cristian's social media. You can find it down in the description below. Thank you so much for your time and your expertise and your generosity. We appreciate it.
It's been a pleasure, and best of luck in everything.